Chapter 11, Test Review. The Fourth Amendment only applies to issuing of search and arrest warrants. That's false. It applies to more than just search and arrest. The Fourth Amendment mandates that police officers have probable cause in order to make an arrest. That's true. Only a person whose reasonable expectation of privacy has been violated can petition the court to exclude evidence obtained in violation of the Fourth Amendment. True. A search warrant is not valid if the facts used to establish probable cause were stale or old. That's true. Officers are exempt from the knock and announce procedure if they are executing a valid warrant in a commercial building. Evidence seized in violation of the Fourth Amendment is inadmissible. Back up. Evidence that officers seized in violation of the Fourth Amendment is admissible if the same evidence was discovered by an independent source using appropriate methods that do not violate the suspect's constitutional rights. That's true. The public safety exception to the exclusionary rule. That's a weird question. Statements made without coercion during questioning conducted in violation of Miranda can be used during trial to impeach a person who made the statements. That's true. The Fourth Amendment prohibits unreasonable search and seizure. Standing refers to the right to ask a court to take legal action. Information supporting issuing a search warrant must be made under oath or affirmation. Facts used to support probable cause for a search warrant must not be stale. The police do not need a warrant to enter a house in emergency situations to render medical aid to people in the house. A protective sweep allows an officer to search the immediate area for people who may ambush the officers. When executing a search warrant, officers may search only in locations specifically described in the warrant. When are the police allowed to search people when executing a search warrant? Police can do a thorough search of people on the premises only if the warrant specifically authorizes the search of those individuals. They can do a pat-down, which we'll talk about in the next chapter. The exclusionary rule currently applies to both local and federal law enforcement agents. Assume that the police illegally arrested John. Incident to the arrest, they searched him and found counterfeit money in his pocket. The officer asked John where the money came from. John told the officer that his friend Fred printed it. If Fred is charged with counterfeiting, he can have the evidence found in John's pocket ruled inadmissible based on fruit of the poisonous tree because they illegally searched that. There was an illegal arrest, so that's fruit of the poisonous tree. Let's do another example. Officer Jones obtained a confession in violation of Miranda. In the confession, the suspect indicated he had hidden stolen diamonds in the park in a soft drink can. A city park ranger found the diamonds before the police had a chance to recover them. The diamonds will be admissible at trial because an independent source found the diamonds. George was arrested for kidnapping someone for ransom. The kidnapped victim, who had severe medical problems, needed regular medication, had not been found. Immediately upon handcuffing George, an officer demanded to know where the victim was. George gave the officer the address. George's statement will be admissible under the public safety exception to the exclusionary rule. If officers obtain a search warrant but fail to follow proper knock and announce procedures, everything they seize while properly executing the warrant will still be admissible. That is the end of Chapter 11, Test Review.